All right, Missy Torres.
Oh, to the front. Good morning.
Parents?
All right, are we here for sentencing?
I believe so, Judge. We had reset it for a couple weeks. For sentencing only. I didn't know if that meant there would be a TAP evaluation or not, but apparently not. So
Well, on this case, it would be, I think you all, both parties agreed to provide the court with a IC.
oh, well, I guess that would be the state because I certainly don't have access to
Yeah.
that.
Because I believe that the state is silent.
Correct. If I'm not mistaken, Judge, our history is some misdemeanors. Sure. We want to get.
All right, court is calling 2024 CR 5145, State of Texas versus Missy Anna Torres. Could I have parties announced for the record for the state? Defense?
I'm sorry, Robert Burns for Miss Torres.
And are you Miss Torres? All right, you need to speak up so the court reporter can hear. All right, we're here for sentencing today. According to the plea bargain agreement, she pled no contest to count 2 of the indictment. She applied for deferred adjudication. The state is proceeding only on count 2 according to the plea bargain agreement. Punishment is to be assessed at 6 years in the prison, and the state is silent on the defendant's application. The court requested that the defendant's criminal history be provided to the court. There were no objections to the court receiving that from the state. Is that correct?
Correct.
And any objections to the court reviewing that?
No, Judge, of course not.
Thank you, state. All right, the state is silent. Is there anything you wish to say on behalf of your client?
Judge, of course, Ms. Torres is hoping you'll grant her application for deferred. She's in self-employed cleaning houses. She has several customers that rely on her. She has a few kids. She's just asking for the court to maybe direct her to some outpatient treatment because she believes she needs some help with this problem. And other than that, again, she's just hoping you'll grant her application.
All right, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your
All right, you can lower your hand, state your name for the record.
Honor. Missy Torres, Missy Ann Torres.
All right, so you're gonna get drug tested today. What are the results going to be?
They will come back a positive.
Positive for what?
Methamphetamine.
All right, so how often are you using meth?
I only do it when I'm under stress, and I did it because I could get denied for adjudication, so
I'm sorry, what?
I could get denied the application. So I just kind of I just do it when I'm under stress. So I know I have a problem and I don't do it like around my children. I don't do it, every day. It's just, when I'm under stress and I was, really scared. And really under stress. So I don't do it when I go to work. I don't do it, every day, like I said.
All right, so how many children do you have?
I have 3,
What are their ages?
11, 8, and 5.
And where are they now?
2 of them are with their dad and 1 is with my grandma.
All right, with your grandmother, so their great grandmother?
Yes, ma'am.
All right. So, do you help take care of your children?
Yes.
How
I-
often?
I see them every other weekend and I don't pay child support, but I pay them. My exes and I have my daughter. My daughter is with me.
No, you just said your daughter is with the
Yeah,
great
but
grandmother.
I live with my grandmother. This was
All right.
I help take care of her. She
Right.
helps me take care of her.
Okay. So 1, I don't think it's appropriate for you to be cleaning houses
Okay.
because of the nature of this offense. And 2, I don't think it's appropriate for you right now to be taking care of your children.
That's why I'm asking for help, Your Honor.
I'm sorry, what?
That's why I was asking for help, Your Honor. That's why.
All right, your help is not going to be outpatient treatment if I grant this application for deferred adjudication. So you're going into custody today.
Okay.
All right. So it's just a matter of what I'm going to do with you. I will tell you the court's issue, and if you want to address this, I know the state is proceeding on count 2 of possession, but she had a lot of drugs with her.
No,
So I don't understand, if you're working homes, then why do you have a scale with
Right.
you? Because that's, according to this, you had drugs, you had a scale in your purse, and there were baggies totaling 32.0 grams.
well, Your Honor, I was a heavy user back then, and it was.
Oh, you're not, I tell you what, I don't think, and if I'm wrong, correct me, I don't think you were using 32 grams of meth.
It was, it was only 28.
No, you have meth here for 4.964 grams, and you also have meth for 27.459 grams. And what you pled to and count two was a possession 4 to 200 grams. So this is not a possession 1 to 4. So we're talking about 27 grams. And according to the stipulations, that what was found in your bag, it says, I searched her bag, and inside a Paris Hilton makeup bag box were baggies, a scale, and crystal-like substance inside a cut vacuum sealed bag. That's from your Paris Hilton makeup bag.
So what I had, the meth was it was double bagged in a sandwich bag. So yes, ma'am, I know it was 20, but it's because that was my personal. I didn't have any other. And last time I went, they tried to only give me which was 14 grams. So I had to.
No, what I'm telling you is, they said the baggie found in Robert's pocket tested positive for meth and had a field weight of
That was
6.12
Robert's, that
grams.
wasn't mine.
No, I'm not saying that was yours. So the 6.12 grams that were found in his pocket, they're saying that was his, it was in his pocket. But the baggie, which was found in Missy's purse, tested positive for meth and had a field weight of 32.09 grams. Now, mind you, what they do in the field, I already know that testing drugs in the field are not legal for court. So I'm not considering the weight and what they said in the field. I'm considering what has been given to me for laboratory reports. So this was the professionals testing it, not a presumptive. And it says 27.459 grams was the net weight of the meth that you had in your Paris Hilton bag.
Yes, Your Honor. And I will say that I used to use a whole ounce within 2 to 3 days. So I was a heavy user, and like I said, they tried to give me half of that the last time, and right now it's going for 250. So if I'm paying 250, I wanted the whole thing. I wanted to make sure. I'm just being honest, and I'm sorry. Excuse me for being.
No, I
transparent.
want you to be honest, and I want you to be transparent.
I'm sorry for being transparent, but it's something that I feel like I worked for my money, and I didn't want just to get gypped again. I can promise you I didn't sell anything. It was because I've been gypped many times. So I did get it. Now it was double bagged because I don't know, that's the way they gave it to me. I can't, and it is my mistake, and I'm taking full responsibility, but I wasn't selling drugs. I wouldn't. I guess I have a job, and back then I was, a heavy user where I would just do it before work, after work, and I didn't have my children in my life. Now I do have my children back in my life, and I'm trying to be a good mom. So I thank you for, giving me an inpatient program.
Well, no, I'm not saying I'm going to give you
Oh, no, I'm
inpatient.
sorry.
What I'm saying is that you're not walking out of this courtroom today.
Mhm.
Either you're going to be going to prison, or either you're going to be going to inpatient treatment. So it's very important that you be 100% honest with me, because I'm telling you, the state proceeded on a possession, but the amount of drugs you had and the way they were packaged, that's concerning for the court. So you're saying that you just bought a bunch of meth and you were saving it up for use?
So I would use within 2 to 3 days, that was all my personal. Like I said, they tried to sell me half of that one time, and I went back to the same person, but I said, I'm gonna weigh it myself to make sure I'm getting the right amount, because I'm an addict. I'm sorry, I am. And we're not.
So you travel with your own scale?
Well, at the time I did, because like I said, I've been gypped, and when you're an addict, that's all you think of, just how to get, make sure you're getting what you need. And honestly, I can see where I made my mistake, but I'm being honest with you. it was my skeleton measure, so my personal, that's it. And I don't know if Robert would tell you that was my personal as well. Like, I mean, I don't want to call him or anything you can if you want to. But he would tell you that's why I used to pick
Oh, no, I'm not gonna be
days.
calling Robert because Robert probably has a case of his own.
Right. But I'm saying Robert can tell you too, within 3 days, maybe 2 to 3 days, really, it would have been gone and I would have been back doing it again. Now I don't. It was kind of like a stress thing. And
Where did you get your drugs to use today before you came to court?
Just an old friend. I hadn't talked to him since, and it was on Saturday when I knew it was, coming, and I guess I felt, under pressure.
If I
Yes.
say something, I think the fact that she would actually go out and do the same drugs that she's about to get sentenced for in a couple of days, I think really speaks to the fact that she has a serious addiction problem that I think only rehab can treat. And if you decide that's ISF or SATF or SAFE, we understand that, but I think she really needs treatment.
All right, this is what the court is there anything else for me to say? All right, this is what the court is gonna do. I see that she hasn't been to prison before. I'm gonna find her guilty, sentence her to 6 years in the prison, the therapeutic community. There's to be no contact with Robert Marble, give her credit for any time served, and I'll retain jurisdiction.
Okay,
And you can explain to her what that means. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I'll tell them. So here's the thing. When I say that I'm going to retain jurisdiction, what that means is they're going to take you to prison. If you're following the rules at the prison, if you're working on yourself, because they have programs at the prison, your attorney can file a motion. It's called shock probation. Back when I was growing up, they would have scared straight programs. So shock probation is sort of a scared straight program. So hopefully when you go to prison, you will clear your mind.
Yes.
The drug use or the addiction that you have, the craving that you have will be lifted. And if you are doing what you're supposed to do at the prison, if there are no bad reports at the prison, when your attorney comes back for a request for shock probation, I will strongly consider it. So while you're at the prison, you have 180 days. That's when he needs to bring it back before me before that time period. So you're going to do 6 months. And if you are doing well, if there are no write-ups against you, then the court will strongly consider giving you probation. You understand?
Yes, ma'am.
So, well, I mean, these are going to be choices that you make. It's going to be completely up to you whether or not I strongly consider giving you probation. Your attorney will explain it to you further, but any programs that they have at the prison, like the therapeutic community, to address your issue, you need to take it. I know they have parenting classes at the jail. I don't know how long the transfer will be, but you need to take advantage of that. When you see people come before me and they've gone to anger management class, they've done parenting classes, they've availed themselves of everything at the jail and everything at the prison, that is what you need to do. You need to immediately sign up for it. If for some reason there's overcrowding and they don't give it to you, it would be better for you to have signed up for it than to just throw up your hands and say, I'm not trying. Do you understand?
Yes.
And next time, if you have a case before any judge, don't use before coming to court. You understand? But I do appreciate your honesty, but you're going to have to get your life in order. Otherwise, children is going to be without their mom. You understand? All right. Good luck to you. You're welcome.
thank you.
All right. Who's here on Esther Diaz?
I am, Your Honor.
Are you all ready to proceed?
We are, Your Honor.
Could I have a file stamp for Probation, please.
Stand right here.
Thank you. All right, court is calling 2023 CR 8835, State of Texas versus Esther Diaz. Can I have parties announced for the record for the state? Defense.
Joseph Appelt.
And are you Esther Diaz?
Yes, Your Honor.
All right, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Esther Diaz who was placed on deferred adjudication in 2023 CR 8835 for the offense of harassment of a public servant on February 15th, 2024 for a period of 3 years? Is that you?
Yes, ma'am.
All right, stayed.
Yes, Your Honor.
Which allegation are you proceeding on?
Violation condition on or about the 28th day of February 2024 in Bear County, Texas. The defendant, Mr. Marie Oriana Diaz, community office tampering with electronic monitoring device.
How do you plead to that? True or not true?
True.
All right. Are you proceeding on any other allegations?
We haven't been the remaining allegation.
All right, any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Agreement in this is that we both believe that Ms. Oriana Diaz should have some sort of treatment. We disagree about what that treatment is.
Yes, Your Honor. In other words, the agreement would be to continue her on her deferred alternate amendment conditions for some form of substance abuse treatment. But as Mr. Edelman has indicated, we don't agree on what type of treatment that should be and exactly where. We would leave that to the court, and I would like to address the court with respect to that, Your Honor.
All right, so let's address the tampering with the electronic monitoring device, and then we can address if the court is going to continue Ms. Diaz or not.
Yes, Your Honor. At the time that occurred, at the time that Ms. Diaz had the device on, she was in a, shall we say, very negative relationship with a gentleman who was the father of her now 2-month-old baby. CPS subsequently had gotten involved dealing with that situation, as well as her other 5 children. One of her children had been involved in drugs, and it has to do with, I'll give you his name, it's Domingo Herrera, who was a negative influence on the other children as well as Ms. Diaz. She has since gotten away from him. She cut the monitor off because she was dealing with the rather exigent circumstances with her oldest child, who is 16 years old. That child is now in the juvenile system because of some of her drug issues and other issues that were going on. That situation is being resolved. There is a CPS case which is open with Ms. Diaz, which she was following and being involved in with their services prior to coming to court, being in custody now for this the violation that she's pled true to. Some of the services they were recommending had to deal with relationship counseling, dealing with anger management counseling, as well as substance abuse counseling. With respect to that, her she does have 6 children. The 16-year-old, actually, she's not the oldest. The 17-year-old is with her mother, which is the child's grandmother. The 16-year-old is in the juvenile system, being taken care of that way. 3 of the children are with her ex-husband, and then the young 2-month-old child is in foster care right now. Her hope is to try to reunite with the 2-month-old and the other children. It's my understanding, as reported by Ms. Diaz, that CPS, that case is rolling forward, and there's some sort of a proceeding in October of this year that she's trying to meet all the requirements for their purposes. While she has been in custody, which is 110 days, Your Honor, she has completed an anger management class. She has 2 more classes to go to complete her healthy relationships class, and she's been in substance abuse counseling as well, 2 more classes, and she'll get a certificate of completion for that class too. She informs me that Mr. Herrera, she doesn't know where he is, no contact with him, doesn't want anything to do with him. It's her information through CPS that he initially began, but he has not cooperated with CPS. He hasn't done anything. And so their process, quite possibly, I haven't seen the pleadings, but knowing how they work, they may be trying to terminate his parental rights as a part of the CPS program. We're not quite sure. However, from her perspective, she doesn't want anything to do with the man at all because of the problems that he has caused her and her children.
All right, state, you're requesting what type of treatment?
Safety, Your Honor.
All right. So I have a few questions. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Esther Marie Oriana Diaz.
All right, and defense, if ever you want to jump in, feel free to jump in. All right, so what are the ages of your children?
17, 16, 14, 12, 5, and 2 months.
All right, so the 2-month-old is in foster care
Yes, ma'am. Yes, Your Honor.
and the 5-year-old is with your ex,
Yes.
and that is not Mr. Herrera.
No,
And the 12-year-old is,
my ex-husband as
14?
well.
and the 16-year-old,
She's in juvie.
and the 17-year-old with the grandmother.
Yes.
All right, so the 16-year-old, why is the 16-year-old in juvenile custody?
She kept running. My mom was having problems with her.
Okay, so she was with your grandmother.
Yes.
All right. Oh, I don't want to go into great detail. I'm just trying to figure things out.
Yes, ma'am. Yes, Your Honor.
So now here's my question in defense. If you want to jump in, feel free to jump in. I don't understand how cutting off the monitor has anything to do with anything. I mean, it's not as though Mr. Herrera was monitoring her. It's not like if she's on GPS, he's monitoring her so he knows where she is. It's probation that was monitoring her.
It had to
Yes.
do with,
I'm sorry, go ahead.
it had to do with the fact that she was previously ordered to complete Alpha Home. And she couldn't do that with the monitor on. And that delves into, and it is intertwined with Mr. Herrera and the relationship that she had with him. And so she did not complete Alpha Home. She in essence left Alpha Home after 1 week.
Okay, so she was in Alpha Home on GPS
Yes, Your Honor.
and she cut the GPS monitor off.
Yes, Your Honor.
Yes.
Sorry to cut. It wasn't necessarily that way. He misunderstood. What I meant was my daughter was giving my mom problems. It wasn't necessary because my ex-boyfriend. It was because my daughter, nobody can handle them. And they only listen when I'm there. And so I had to cut my monitor to go get my daughter.
No, you didn't have to cut your monitor off. You could have called probation and said,
I called them, my mom called them, they didn't want to do nothing. They didn't, my son's probation officer is the same probation officer for my daughter. They didn't even go look for her. Little did they know my son was even doing other things. I had to be the one keep calling and calling, and they weren't doing their job. Secondly, my daughter was going to the Westway apartments where there's a bridge, where there's a lot of homeless people.
all right, so here's the thing. I understand what you're saying about probation not doing their job, but honestly, you were not doing your job as a parent because that's why probation is in their life. And the government, honestly, even when people are juveniles, it's really not the probation's officer job to raise your children. That's your job. And the fact that your child ran away still doesn't excuse your thinking, which is, I'm going to cut off my monitor because my child ran away and my child will only listen to me. If your child will only listen to you, why are your children living with the grandmother instead of you?
Exactly. I was just trying to take my daughter back to my mom's and let her, turn herself in, do it the right way, so I can turn myself in, so I can be at peace and know that she's okay. While I'm doing my, doing what I have to do as a parent.
Well, let me just tell everybody, one, I don't even think she should be continued on probation. I think she should be revoked. But what I can tell you is, I am not going to do the treatment that you want. It's going to be safety.
Okay, it's fine.
So, well, no, you need to listen.
Yes,
So even if I consider continuing you, it's going to be safety. So everything else is off the table. Any questions?
Not from the state, Your Honor.
Any questions?
Not from the defense, Your Honor.
All right, probation, what are you requesting?
Judge. Felony drug court, she was initially accepted into felony drug court and then the monitor issue happened. So then they rejected the case, it came back over. We did refer her to felony drug court. And at that point, the ADA down there opposed the reentry. I didn't get any further information on why they opposed, it was just ADA opposed. We did also do a TAP evaluation while she's been in custody, and the TAP recommended for safety. I would ask, that she be given credit for the anger management course that she's taken while she's been in custody, and defer to the court on in regards to treatment.
Okay. So probation wants to continue her?
Yes.
Okay. All right, this is what the court is going to do. I'll deny the motion. Alternate amend conditions to extend for 2 years. We can do a referral back to felony drug court. And if not accepted, then safety.
Judge, I would like to point out that referral was just back to as a whole.
All right.
If I'm saying the ADA opposed it, and that's why she wasn't granted, or she wasn't accepted to drug court. Otherwise, she met the requirements for it.
Who's the ADA?
It doesn't even give you that information. Judge, it does say that she met the criteria. That's all I have.
And I have counseled Ms. Diaz on how stringent and how difficult drug court is to complete. And she has informed me that she is ready, willing, and able to do whatever she needs to do.
All right, just one moment. All right, so here's my other question. Has anyone looked into if she has a CPS case, CPS has a treatment court there as well. Has anyone checked to see if they will accept her?
I have not, Your Honor.
All right. Yes,
I have a outpatient visit with the CPS worker on the 3rd. And she was asking, well, telling me that if they didn't have classes for me here, that they would provide the classes for me there.
all right. So what's going to end? I can tell everybody what's going to end up happening, right? And y'all tell me if you all want to continue down this road of sending her to safety. In CPS cases, you only have a year. Counsel, as you know, to get your act together for them to consider placing your children with you. Sometimes they will extend it, maybe extend it for 3 months. Most I've seen is 6 months, and that's it. So if you're not accepted into felony drug court, it's going to be very difficult for you when you're sent to safety. So I'm going to ask that she be re-referred to felony drug court, and maybe your attorney can speak to them at felony drug court and talk to the ADA and see if they're willing to reconsider. But if you're not accepted in felony drug court, you're going to go to safety.
Yes, Your Honor.
So there's a referral to felony drug court in custody. If not accepted, then safety. Is there anything else from either side?
Nothing from the defense, Your Honor.
Okay, and just one moment. Yeah, okay. All right, good luck to you.
Thank
Oh,
you.
and I'm sorry, one more thing on the record probation. She'll receive credit for the anger management course.
I received my other 2 certificates in 2 weeks.
All right, sure.
It should
Just,
be in the system, they said.
all right, just let probation know.
Yes, Your Honor.
All right, thank you.
Thank you.
Yes, thank you. Thank you. Good morning. All right, court is calling 2023 CR 10004 State versus Tyler Ashbaugh. Can our parties announce for the record for the state? Defense,
Nathaniel Navy for Mr. Ashbaugh.
and are you Mr. Ashbaugh?
Yes, Your Honor.
All right, defense has filed a motion to amend conditions of bond. State, have you had a chance to review that? All right, state, do you have any objections? All right, defense, you may proceed.
Yes, Judge. So essentially, we would just be asking for two things. Number one is to amend Mr. Ashbaugh's current conditions from GPS full house arrest to GPS partial to allow him to work. And just a little bit of background behind that, Judge. We understand that the allegation is serious. However, Mr. Ashbaugh has been on GPS full house arrest for 2 years at this point. The case was pending on intake for quite a while. He has had no recorded violations of his GPS monitoring device. With Mr. Ashbaugh being on full GPS house arrest, he's had to live with his father to help support him. His father is older, in his 70s. He lives there with his wife and their daughter as well. This has placed not only a immense financial burden on Tyler and his wife, as they've had to move in with his father because Tyler can't work, but also on Tyler's father, who is now in his 70s, having to work extra and stress more about their finances. Tyler would like to have the ability to set up an interview and hopefully get hired somewhere and work to help contribute for his family, his children, his legal expenses, just to ease the burden not only on himself, but on his family as well, Judge. And as I've come in front of you before on another time on this case, I said, any little allowance you've given Tyler to do something, he's never abused the court's trust in this case since it's been pending on bond. And I think that will continue. He obviously takes this case very seriously. He takes his pretrial conditions of bond very seriously, as are evidence that he has had no violations since he's been on this monitor. The second thing that we would be asking for is the ability to go to, I forget the name of the hospital. What was that? Stone Oak Methodist Hospital, when his wife is due. She's due at the end of this month, but from talking to them, it may be sooner. Obviously, and I maybe seek the court's guidance as well with how to word this on GPS if you were to consider it and grant it, Judge. But for a one-time, and I don't know if it's to say tracking or one-time ability to go to the hospital, because it's going to be hard to schedule this. I think, just knowing from my experience, if I tried to schedule it, I think he would miss it. Or if he tried to schedule it, I think he would probably miss the birth. So just a one-time ability to go to this hospital, stay there until she's discharged, and then come home whenever that is. Obviously, pretrial services would have the address of the hospital ahead of time. He could even give them notice as he's about to go. But I think if he had to try to get permission and schedule it, he may miss it. But maybe if there was some way to say, it's either a one-time tracking ability where he's approved to go to this hospital at an unscheduled time for the birth and come home, go nowhere else but the hospital. That's what I would be seeking as well, Judge. And I know you've asked this before, so I've talked to him and his wife. They have had one other kid together. She said he was helpful. He didn't pass out. He wasn't
Okay,
just somebody who was actually a burden on her, but he did help. So she would like him there, Judge, if it's possible.
All right, so let's start with first. State, do you have any objections to him being allowed to attend the birth of his child at Stone Oak Methodist Hospital and to remain until discharge of wife and child?
No, Judge, just as long as it's pretrial and abides by the GPS.
All right, so that will be granted. Now, the next thing, with a request for him to be able to work while on GPS.
Judge, at this time, due to the allegations against the defendant, we were opposed to any other type of GPS other than full house arrest.
Okay. All right. This is what the court will allow him to have employment. I don't know the nature of the alleged facts of offense other than what I see that he's been charged with. So you will be allowed to, once you're employed, to work. But I know now that a lot of employment, the way you get interviews is online. Am I correct in that assumption?
Yes, Your Honor.
All right.
Yes, I think the one that he's attempting to interview with, they do want you to come in person, right? It's with Kia World Car Mazda for a phone representative. They basically said, come in
All
9.
right, so here's the thing. If he is going to be working at a car dealership, I'm not going to allow him to be working at a dealership where he's driving around. So what
Understood.
would he be doing if he were to be hired? Yes.
Phone
Okay.
representative, ma'am.
All right, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Tyler Ashbaugh.
All right, if you're hired, what is your position? What are your duties?
I'm not too sure necessarily, but it's a phone representative. I'm guessing I'll be taking phone calls about probably price inquiries and such things.
All right, and so will you be working from home or working at the dealership?
At the dealership, hopefully.
All right, so then what I'll do is I'll allow him to go to the interview. And when is this interview?
He told me just to come in from any time from 9 to 7, Monday through Saturday, and ask for Ed,
And you said Monday through Saturday?
Monday through Saturday.
All right, so I'm gonna allow him to go to the interview. And you will need to schedule a time with them. And that time needs to be, state, I know you're not in agreement, but what hours? Because I'm not gonna allow him to set his hour at 7 PM. So it's gonna have to be in the morning time. And what hours?
9 to 11.
All right, so he can set his appointment anywhere from 9 to 11. And I'll allow you 30 minutes beforehand to arrive. And then 30 minutes to return. Is that enough time?
Yes, Your Honor.
Yes, Judge.
All right, and you will need to let GPS know. Are you gonna be there at 9, 10, or 11? Do you understand?
Yes, Your Honor.
All right, and then once he is employed, my mom always says, once you have the interview, usually they're gonna hire you. So we'll come back if he is employed. And then counsel, if you just come in, if he ends up receiving the job and his duties are as he's telling me, I'll allow it.
Okay.
So and I'm sorry, 9 to 11 AM, you're gonna have to get that appointment either Monday through Thursday, not Friday and Saturday. If there's some issue where they can only do it on a Saturday or only do it on a Friday, you need to come back and let the court know that's the plan.
Yes, Judge.
All right, is there anything else?
Just one other thing, Judge, because I know it's a possibility that he does the interview, they do the background check, they see that he's charged with this, and then they say no.
Mhm.
If there are other opportunities for job interviews, but this is the one that's immediate, if he has any other possible interviews, do we need to come in again, or is he okay to schedule interviews, but just tell his pretrial services officer? How would the court like us to do that?
Well, to make it easier on everybody, so people won't have to come down, counsel, if you want to include an email, include Mr. Garhan in that email, your client in that email, and include me, of course.
Of course, Judge.
And you will put down where he is seeking to have an interview. And in each of those emails, I'm gonna need to know what his proposed duties are if he's hired. Because there are just some things that I'm not gonna allow him to do.
Of course, Judge. Understood.
All right, is there anything else?
Not at this time, Judge.
All right, and is everyone, I'm sorry, does everyone approve of the court's plan as far as if there are different interviews that can be asked through email?
Yes, absolutely, Judge.
Not opposed, Your Honor.
All right, okay, thank you.
Okay, thank you, Judge. May we be
Welcome.
excused?
Yes.
Thank you.
All right, court is calling 2024 CR 3954, State of Texas versus Walter Charles Weller. Can I have parties announced for the record for the state?
Andrew Harris, Edelman.
Defense.
on behalf of Mr. Weller.
And are you Mr. Weller?
Yes, Your Honor.
All right. Counsel, have you received all the discovery and did you review it with your client?
We have, Your Honor, and I have.
Court will find that the state is in compliance with discovery. Mr. Weller, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
Did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And
Your
did you
Honor.
intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Weller, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is requesting a $2,000 fine and the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Contained in Exhibit 1 and attachments, Your Honor.
I have no objections, Your
All
Honor.
right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Tony Adonis, yes, Your Honor.
After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I don't know if the court recalls, but the court had reset this case a couple of weeks so that Walter could finish the dual diagnosis recovery program
Yes.
at Ripple Ranch. I just wanted to show the court that he has in fact completed that program and successfully completed it and has received a certificate of completion.
All right, thank you. Excuse me, could you hand that to probation, please? All right, is there anything else?
Other than Judge, he seems to be doing very well. He tells me he learned a lot from that program and he's excited to continue.
All right. So is he still working with them, an outpatient?
They have recommended outpatient program for him, Judge. He's got a couple of documents that indicate the different programs. I'm not sure if they're in San Antonio, though. Is that right?
Yeah, well, then I also was going to attend a church in Elmendorf where I live. It's a Catholic church I normally went to, but I stopped going in 2020 with the COVID. And just never went back.
All right, and the facility that he was previously with, what's the full name?
It's a Ripple Ranch Recovery Center,
I'm sorry,
Ripple Ranch Recovery Center,
RIPP.
RIPPLE. Yes. No, it's in Spring Branch.
So where's Spring Branch located? What county?
281 North, I believe it's Blanco County, isn't it?
I think so.
I think it's Blanco County.
All right, so,
And there was a 30-day inpatient program that he finished.
all right, so does he want to be transferred to Spring Branch?
No.
So where's he going to continue with his outpatient treatment with
It
them?
would be in Elmendorf, Texas, where I live.
All right,
Yeah.
and do you have children?
Yes, I have 3 now, Your Honor.
All right, and why was Candace, the juvenile Candace, does she live with you?
She lives on her own now, Your Honor.
And how old is she?
She's 19 now.
Okay. All right, this is what the court is going to do. There's going to be a $2,000 fine that will be probated, 2 years deferred adjudication, 120 hours of community service restitution. I'm going to order parenting classes. Once he completes that, that'll be deemed satisfied. We'll do a transfer to Elmendorf, Texas. You're not on probation in Elmendorf until they accept the transfer. You're to continue with your treatment with.
Elmendorf is Bear County.
Yeah.
It is so far. I mean, Elmendorf is in Bear County, but I will tell you, I represented a child and that was one of the longest drives ever. All right, thank you. So he will not be transferred to Elmendorf because he's already in Bear County. Okay. So, but he's it's probation. He can live in Elmendorf then. There's going to be parenting classes. Once you complete those, the community service hours will be deemed satisfied. Are you to continue your treatment with Ripple Ranch Recovery System? There's going to be anger management, regular random UAs,
Okay.
regular reporting by Zoom or in person. Are you employed?
Not at the moment.
All right. There's going to be proof of employment within 45 days. There's to be no employment as a home healthcare provider or with minors. I'm going to ask for field visits 1 time per month until completion of TAP evaluation. And I'm going to order TAP evaluation and probation. If TAP recommends inpatient treatment, we'll start with outpatient treatment. All right. Probation, is there anything else he needs? Is there anything else you need from the court?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing: to be successful on probation in this court, communication is key. If you have a question, ask your probation officer. If you feel as though they're not addressing it, you can always come back to the court and we'll address it. You understand? All right, good luck to you.
Thank
Thank
you.
you. Maybe
Welcome. All right, so we're going to take our break and we'll be back.